Live.
Good evening, everyone. My name is Maguire Radosevich, and I'm the president of the Federalist Society chapter at the University of California, Berkeley School of Law. Tonight, we're glad to be partnering with the Federalist Society National Organization and the Student Division in their attempts and their efforts to host a Zoom series called Challenges to Originalism, which features a rotating student chapter president interviewing originalism expert Professor Lee Strang, who will lay out 10 of the most common criticisms of originalism from both the left and the right and respond to some of the legal theory's most formidable foes, followed by a live audience Q&A. Today is challenge number 7, which is Challenges to Originalism. Originalism is inconsistent with democracy. All audience members should feel free to submit questions via the Q&A feature on Zoom. And with that, I'm blessed to introduce our guest this evening, Professor Lee Strang, who is the John W. Stepler Professor of Law and Values at the University of Toledo College of the Law, and also the director of the Institute of American Constitutional Thought and Leadership, also relevant to both today's discussion as well as the rest of the series on challenges to originalism. Professor Strang is the author of Originalism's Promise, a natural law account of the American Constitution, which was published in 2019. So Professor Strang, to get us started, we're talking again today about whether or not originalism is consistent with democracy. And I think before getting into the main criticisms and the main critiques that people make on this point, I think maybe the first question to be asking is whether this is the right question to begin with. There's a lot of talk about maybe the framers didn't intend for us to live in a democracy. Maybe the constitutional system doesn't espouse democratic values 100% of the time. Is democracy really the value that we should be searching for?
Yeah, thanks, McGuire. Thanks for hosting this evening. This is one of the really fun topics because the criticism of originalism being consistent with, or as originalists sometimes have argued, actually required by democracy, has a kind of a strong influence in the evolution of originalism. So this will be a fun one tonight. So to respond to your question, let me just talk about the last part first, right? So why is democracy valuable? And there's a way in which, at least as a political matter, nobody can dispute in America that democracy is valuable. And it's certainly not a proposition that I'm going to dispute tonight. But I think what I would say in response to your initial question would be that to just think about why is democracy valuable? And so the perspective that I come from is from the natural law perspective. And from that perspective, the key goal of human life as individuals is human flourishing, and the key goal of a political community is the common good. And so democracy is a tool to achieve the common good in certain circumstances, and therefore human flourishing. But democracy itself isn't an end state. So it's an instrumental good, but not an end state good. And so different times and circumstances could require a democratic system of government, could require an aristocratic system of government, could require a monarchical. And you could imagine 13th century England, probably not a good idea to have popular democracy for a variety of reasons. But in a country like the United States, which has a very literate populace, has an informed populace, that more democratic institutions would be valuable. I would say one more thing about this as well. So within the natural law tradition, since human beings are rational beings, one of the ways we exercise our rationality is through self-governance of each other, of us as individuals. But we also exercise our rationality to its fullest extent by participating in the self-government of our political community. So there actually is a way in which, if you were to think about different forms of government, the natural law tradition is a thumb on the scale in favor of choosing a more democratic option to the extent that it allows the ability of citizens to participate in their own self-governance as a political community. So let's go back to the first part of your question. What did the framers think about democracy? As a general rule, the framers were not big on democracy, if we mean by democracy popular rule. And if we had an Aristotelian conception of democracy where it was the polis, the whole group of citizens engaging in democratic rule, they came to that conclusion from a couple bases. One was in reading history, many philosophers in the Western tradition, including Aristotle, had negative views because of what appeared to be the kind of breakdowns and malfunctions of democratic processes. And in fact, James Madison, the summer before the Philadelphia Convention, basically locked himself in his room in Montpelier and spent the summer looking at what were all of the previous, what we would say, Republican versions of government. Why did they all fail? And try to come up with reasons to come up with a different solution. And so when you look at our current Constitution, at least if you imagine democracy meaning popular government by people today, there's not a lot of that going on. You can see that when you look at how do people get elected. So under the original Constitution, only the House members were directly elected, even there, by relatively small franchises. When you look at what was identified as the preferred form of government, Article 4, Section 4 prefers the Republican form of government as opposed to a democratic form of government. And then when you think about the reasoning that went into Article 1, James Madison in Federalist 10 put a thumb on the scale in favor of a Republican form of government because of what he talked about as something called upward filtration, that actually the election process is going to select over the long term for more better leaders effectively. So the framers themselves probably had a fairly dim view of democracy. And so to kind of summarize, the point in response to your question, on the one hand, democracy is valued by all Americans. The key question is it an instrumental good or is it something that's an ultimate good that can justify a political system?
This is a lot to unpack there. And what I hear you saying is that there are democratic aspects and facets of our system, and there are ways in which the Constitution was meant to value the voice of the people, and it might be a means to an end rather than an end in itself, but still, even according to the natural law tradition and our constitutional tradition, is something that's not worth dismissing. And so you're starting out kind of broad. What are the main, most salient arguments that critics of originalism make on this point that originalism is inconsistent with democracy?
Yeah, let me use this to step back in time just a little bit. So when you think about the first generation of originalist scholars, people like Robert Bork writing in 1971 or Raoul Berger writing in 1978, what they were facing was, from their perspective, you had a Supreme Court that was kind of running haywire. The Supreme Court was striking down acts of the elected branches, and from their perspective, from the perspective of democracy, meaning majority rule now, what you had was the Supreme Court basically stamping on democracy over and over. And so Robert Bork, in his seminal article in 1971, argued that one of the virtues of originalism is that it's democratic in two ways. One way was you would have fewer instances where the Supreme Court, using a non-originalist methodology, would be striking down acts of state and federal elected branches. But number two, and maybe a little more deep, but still under-theorized, honestly, was that Bork had argued that so long as the Supreme Court was enforcing the original intended meaning of the Constitution, it was following what was called the Madisonian, what he called the Madisonian system, which was this idea that through popular referenda, some issues are taken off the table for democratic processes, i.e. those that are originally intended in the text. And so either way, when the Supreme Court is deferring to elected branches, democracy wins, or when the Supreme Court is enforcing the original intent, democracy wins as well. And why was Bork so focused on democracy? Well, I gave one sociological reason, which was that the Supreme Court seemed to be doing a lot of things inconsistent with democracy. So think of cases like Miranda versus Arizona. But there's another kind of theoretical reason. The most influential 20th century law professor was a person named Alexander Bickel. Bickel wrote a book, maybe the most famous constitutional interpretation book of the 20th century, called The Least Dangerous Branch. And Bork was not only a personal friend of Alexander Bickel and a colleague of Alexander Bickel, but was incredibly influenced, like other folks were, by Bickel's argument. And Bickel was actually the person who coined the phrase in that book, the counter-majoritarian difficulty. And maybe something that you have heard in your common law classes as well, where Bickel said the problem with the federal judges exercising judicial review is that they're they're acting contrary to democracy. And so constitutional interpretation, not just in the originalist side, but actually kind of all across the spectrum during this time period of the 70s, 80s, and into the 90s, was focused on we have to solve the counter-majoritarian difficulty. And that's where originalism's initial position was. And then the critics of originalism were also operating from that perspective. And so what did the critics argue? The critics argued that originalism in practice wasn't always consistent with democracy understood as democratic processes today. So you've taken constitutional law, and you know that some decisions that would follow the original meaning would augment democracy, and some of them would not. So arguably, Miranda versus Arizona is inconsistent with the original meaning of the Fifth Amendment, and so the Supreme Court would have upheld Arizona's police interrogation techniques. And so from this perspective, that would have been a democratic process or a democratic idea. But there's lots of other cases that you've covered where an originalist interpretation would not lead to following democracy. So famously, in Wickard versus Filburn, the Supreme Court affirmed the Agricultural Adjustment Act, which was passed by Congress, and arguably an originalist interpretation wouldn't have done that. So the first major criticism was that, hey, originalism doesn't always do what elected branches want you to do. But then there was an even deeper criticism. So one part of Bork's argument was what he called this Madisonian compromise. And what critics argued, persuasively, I think, was that in two ways, the Constitution was not democratically adopted, at least by Americans' lights today. So one was when you look at the breadth of the franchise, it was really narrow. Not a lot of people, not a high percentage of the population of adults got to participate. But then even more tragically, entire groups of Americans were excluded from participating in the franchise based on arbitrary reasons. So it's hard to argue that the Constitution has some kind of democratic pedigree, at least by today's lights. And so critics articulated these two criticisms, that neither currently nor in the originally intended meaning is originalism consistently or always democratic. And so that undermined that first generation of scholars' arguments.
So I want to take that most recent set of critiques that you just made, and I want to couple it with something else. What you talked about was the scope of the franchise and how it was narrow. And that seems to undercut Bork's assumption that the popular referenda, that there really was a popular referendum that took issues off the table. And you couple that with how difficult it is to amend the Constitution, how, according to the Constitution's own terms, which were ratified by that same, what critics would say, a flawed popular referendum.
That's right.
It requires, it's an onerous burden, requiring 3/4 of the states and 2/3 of either both houses of Congress or of the state legislatures. So, coupled with the point that you made about the scope of the franchise, how do originalists come to terms with that when trying to make the argument that originalism is compatible with democracy?
Yeah, so it's I would say that the pro-originalist is consistent with democracy arguments actually went downhill as a matter of just the people making them beginning around 1980 or so. So we actually did not have many of those kind of arguments after around 1980, because I think most people agreed with the criticism that you and I were just articulating. But I would say in the last 20 years or so, among many other normative justifications for originalism, originalists have also come back to this originalism is justified by democracy argument. And the two best examples that I would give our audience, one is a book-length argument by Keith Whittington, 1999, called Constitutional Interpretation. And there Whittington, and one more precatory comment, both Whittington and the other scholar I'm going to refer to in a second, what they do is they reconceptualize democracy. Democracy isn't, either today or in the past, majority rule. Democracy is something, it involves popular input, but it's more than just majority rule. So here's Whittington's position. So Whittington's position is that in order for the American people, however conceived, past or present, but including the people today, to be able to exercise constitutional choice. And what he means by that is you could have the American people adopt or amend, which was one of your points, the Constitution. In order for that to be a plausible operation, those constitutional provisions, either the original ones or subsequent ones, have to both be respected by the government officials and have to be interpreted in a way that's consistent with what the popular will, when those amendments were adopted, was. Because otherwise you'd have futility, right? The American people would adopt an amendment, and then government officials could ignore it, or American people would adopt an amendment, and then American officials could change its interpretation. And maybe one example that our audience who are law students have come into contact with is the Privileges or Immunities Clause. So the Privileges or Immunities Clause was arguably the most important provision in the 14th Amendment passed by the Reconstruction Republicans. And it was meant both as a shield, as a sword to protect newly free Black Americans and their allies in the South. And then if you've taken constitutional law, you know, in the slaughterhouse cases, it was effectively eviscerated. And so from Whittington's perspective, what happened was you had this incredible moment of constitutional change and codification in the 14th Amendment, but the premise of it, which is that the government officials are going to follow it, didn't happen. So it's an example of why originalism would have facilitated constitutional popular sovereignty, but in fact, it was undermined. The other scholar that I think has articulated a couple of years ago a kind of a related, updated, and I would say a very nuanced argument is Joel Alisea from Catholic University, where he argued in an article in the Notre Dame Law Review, again from the natural law tradition, that from that perspective, one of the key questions is who has authority in any political community. His argument is that the entire people have authority because there's no basis and reason to distinguish between one American or another, or one group of Americans and another. And so his position is that this popular sovereignty was exercised by the American people. They have to exercise it to create an authority that's going to secure the common good of the community. How did the American people exercise it? They exercised it through transmitting that political authority that they had to the Constitution, and the Constitution is the mechanism to secure the common good of the community, which is the goal of a political community in the natural law tradition. And then how does originalism enter into that? That government officials have to follow the original meaning in order for that original transmission of authority from the American people to the Constitution to be effective. So one move, summarizing those 2 points, McGuire, is to change the understanding of what democracy is. Democracy isn't just what a majority did today or a majority did in 1789. It includes the current capacity of the American people to live in a constitutional government. So I'd say that's one response by originalists to the critique. The second one is to say democracy is a good, but it's actually not the kind of good that can justify a political system, that can justify a legal system, including a constitution. So what most originalists, I think this is probably where the center of gravity is, most originalists have abandoned the argument that democracy is the justification for originalism and have offered a variety of other arguments for originalism. And one reason is because when you look at, as we talked about earlier, what decisions would originalism lead to? Sometimes they're democracy enhancing, and sometimes they're not. And so if that's true, then it seems like democracy, at least as conceived as current majority rule, is not a justification. And so you have originalists justifying originalism based on natural rights, based on utilitarianism, based on virtue ethics. And so originalists have said democracy is valuable, but it's not the kind of end, it's not the kind of final good that can justify political or legal authority. So I think most originalists have actually moved away from the democracy as a justification argument.
Interesting, and a lot to unpack there. I'm going to continue asking questions, but just going to make a note to please continue and feel free to submit questions via the Q&A feature on the Zoom if you are in the audience. So I think one thing I want to touch on, Professor, based on your prior comments, is you referenced Professor Alicea's article about manifesting will to be governed by a government or a particular government, and that some institution has to have the authority. And I think the obvious question in response to that is the ratifying generation has been dead for over 2 centuries for the most part. And so why should their beliefs about the system of governments, why should their willingness to submit themselves to the Madisonian Compromise, why should their policy values, for lack of a better term, continue to bind this generation when this generation, a majority of them might believe in completely different. Maybe a majority of people don't believe in a right to keep and bear arms under the Second Amendment, but not necessarily enough to inspire an amendment to the Constitution. So what's the response to that?
Yeah, so I think two responses. One, which I'll say just a few words and then move on to a deeper one, One is that even if that's true, right, which is that the original Constitution was adopted by people who aren't representative, or the original Constitution embodies positions that Americans today would not follow. So let's say the right to keep and bear arms is one potential example. What originalists who have justified originalism through other mechanisms would say is that's maybe a cost, maybe not a cost. It actually, I think, depends on the perspective. But that if it in fact is the case that originalism leads to, for example, the most protection of natural rights, or originalism leads to the best consequences as an interpretive methodology, or originalism leads to the conditions that are conducive to human flourishing, then overall and on balance, originalism is still the best theory of interpretation, even if there's a cost in the way that there's a disjunction between Americans' current views of what's best policy in the Constitution. But let's focus on what the originalists who make the democratic arguments are. So both Whittington and Alisea, they don't focus on democracy in 1789, or really democracy today understood in terms of majority rule. What they focus on is the capacity of a group of citizens in a political community to be able to live out constitutional government. So for Whittington, it's the capacity to have a constitution, to have it followed, and to have it amended. And so one of the points that you had made, McGuire, was maybe it's hard to amend the Constitution today. I think Whittington might respond that part of the reason why it's hard for Americans to amend the Constitution today is because we have other mechanisms by which the Constitution is effectively amended, i.e. through Supreme Court non-originalist interpretation. And so people's interests, people's drive, people's energies have been taken out of the Article 5 process and put into the Supreme Court justice confirmation process, which I think as a sociological matter does seem true to me. So on the Alisea point, I think it's actually a really interesting move. It's a complicated paper. I'm not doing it justice in our short time frame here. But what Alisea is arguing is that from the natural law perspective, what a political community is the people who live in that community involved in relationships with each other, not necessarily social relationships, but relationships of justice, relationships of civic friendship. And if one is in that community, here's his argument. If one continues to be in that political community and in those relationships of justice and civic friendship, one is choosing, this is his argument, is choosing to be a part of that political community. That political community had chosen to transfer power from the entire community to one document, which then transfers it to other people. So even if, here'd be his point, even if some Americans today disagree with the right to keep and bear arms as originally understood, that would still be, the Constitution would still be consistent with democracy as he understands it, as the capacity of a political community securing the common good through time to articulate constitutional provisions. And one kind of way that he turns the tables a little bit would be, think of the alternative. Think if the position was, every time we think confidently that a majority of Americans have come to disagree with a provision, or the original meaning of a provision of the Constitution, what that would mean is it'd be very hard to have the kind of stability that's necessary for the long-term flourishing of a political community. That instead we'd have to have, I don't know if it'd be referenda, if we'd have to have other kinds of consistent opportunities for change, and that itself would be damaging to the stability of the political community, which in Alicea's view, one of the points of the community is to secure the common good. So the two moves are to say that other reasons actually support the original meaning, and then the second move is that a different understanding of democracy makes the points that you raised not necessarily relevant to whether originalism is the right theory of interpretation.
So we have one question from the audience that seems to flow nicely from this, again, touching on the ease of amendments. The question is, in your view, would amending the Constitution to make constitutional change easier be useful or detrimental? I think probably the questioner means, although you can take it however you want, useful or detrimental to the vitality of originalism.
Sure, yeah. Let me just step back and talk about Article 5 first. I think most scholars of all different perspectives think that Article 5 is a pretty high hurdle. I personally think it's a high hurdle. When I think of the propositions that Americans either currently or in the past have agreed with, that they've agreed with as in the sense of they're sound propositions that should be part of the Constitution, and they did make it into the Constitution just because of, among other reasons, the really high hurdle that Article 5 has. So I think it's probably the top of the spectrum of reasonableness, and I think that's a widespread view. And so if that's true as a sociological matter, then moving Article 5 down slightly would probably be conducive to the common good of the community. And I think just honestly, as a practical matter, if we had in fact more of a capacity for Article 5 amendments, and in fact, we use that process, that would take out a lot of the pressure for non-originalist precedents, because many people, wrongly in my view, but still reasonably, think that the only way to get real change, practical change in constitutional interpretation, is to get your folks on the court. And so an easier amendment process would make that happen. I actually think we'd end up with a virtuous cycle, McGuire, where we do an amendment, people realize, hey, we can do this again. And then we would take our focus away from judicial confirmations and nominations and put them on textual amendments to the process. So it could actually end up being a very virtuous cycle. So I think and there's one other point too. So when you think about LSA's point earlier, which I agree with, that part of the reason to have a constitution is to have the kind of stability that a political community needs on its fundamental laws. And Article 5 certainly gives us, we've got stability in spades right now, right? When it comes to the text of the Constitution. But if you agree with my previous point, moving that stability down just a notch while allowing a little bit more flexibility probably is the right balance in our political community right now. And in fact, I'm in Ohio. In Ohio, we just had a debate because the Ohio Constitution, like the majority of state constitutions, can be amended by a popular vote of 50% plus one. And I argued publicly that moving it up to something like 55 or 60% would probably be valuable. Now, that's way lower than what effectively I think is the federal system, which is like 85% approval. So it's still way lower, but I think it actually would, we in Ohio need a little bit more stability, whereas the federal system needs a little bit less stability.
One of the other questions that we've received from the audience deals with something that you spoke about a few minutes ago, talking about how one of the ways that we're bound by the Constitution, even if in its originalist form, is by appointments to the Supreme Court in the political process. And that's how people today express their willingness to be bound by the same Constitution that bound generations prior. So the question is, and this deals with a lot of proposals from the left and the center left to increase the size of the Supreme Court. And it seems like that might have pretty democratic effects on the court as an institution, both because more people on the court would present more perspectives that might be held by other Americans, but it would also allow people more of a say, since the current president would be the one to appoint the Supreme Court justice. It would give the current generation more of an impact on the court's jurisprudence. So what do you think about that?
Yeah, so you had given two initial plausible reasons to think that increasing the size of the Supreme Court would make it more consistent with democracy, understood in terms of current majority preferences. The first reason that you gave was that it would increase the variety of perspectives on the Supreme Court. And I'm not sure, I guess I'm not sure if that's true. So if you look at the Supreme Court's composition today, those folks come from a pretty narrow slice of the socioeconomic pie of America. And it's been that way for a fairly long time. So at one time, even as late, I would say, as Reagan, presidents took into account a variety of considerations when nominating Supreme Court justices. So for example, Justice Scalia, I think the clinching argument in President Reagan's mind was, that guy's Italian-American, and I want to win the Italian-American vote, right? And so not necessarily related to his merits, but a political consideration. And previously, one of the political considerations was, I want to nominate people from different parts of the country, different sections of the country. So President Lincoln, for example, had to nominate somebody from the Midwest. And so you had some folks from Ohio, for example. And that has largely gone away, right? As the Supreme Court has become more, I don't know if the right word is ideologically, but jurisprudentially defined. And so now the coalitions are defined. We've got originalist folks and living constitutionalist folks, and that's the paradigmatic reason on both sides. And so I don't know if we'd get more perspectives. That's my first response. Second response, I do think that the second reason that you gave, which is you would have more consistent popular input, could make the Supreme Court more aligned with current preferences in two ways. So one is that you would have if we had a change where every president got at least two nominees, that would mean that you'd have consistent Supreme Court nominees who are more likely to be consistent with the current preferences of whatever the issue might be, as opposed to somebody like Justice Thomas, who's been on the court now for almost 30 years. And his median perspective, his median worldview was formed before a lot of people in our audience were born. And so we get consistent new preferences coming in. And then we also would get consistent preferences from a variety of presidential parties and presidential political coalitions. And so it does seem like that would move the Supreme Court's justices' perspectives more in line with current majoritarian preferences, if that's how we're defining democracy. And there are a lot of proposals. It's actually a proposal I support, which is giving the Supreme Court justices term limits. So that way, in effect, each president would be able to have 2 nominees every term. I think that would decrease the heat on presidential elections and on Supreme Court nominations, so that everybody would know each president gets at least 2.
Wonderful. So I think we're coming up on time pretty rapidly. So I think we're going to do 2 more questions. We'll do one from the audience, then one wrap-up question, and these will both be more big picture questions to bring us back full circle.
Great.
So one of the things that caught me at the end of what you were saying is you said, if that's how we're defining democracy, and that plays right into the hands of one of the questions that we have from the audience about how do we define democracy? Because originalism doesn't seem to be about democracy, but rather having a consistent and a fair way to interpret the Constitution.
Okay. And in your initial question to me, one of my moves was to try and characterize what I think democracy means and its kind of value in the scheme of values in a political community. And so I guess I'm sympathetic to what I take to be the questioner's point, which is that democracy is a good, but originalism isn't about that. And I think that's true. But what the originalist folks who are arguing that originalism is consistent with and supported by democracy, what they're doing is they're trying to answer what I call the why question. So when you think about originalism, there's kind of 2 fundamental questions. How do you do it, which is not what we're talking about tonight, and why do you do it? And one reason why you do originalism, scholars have argued, is because it advances this really, from their perspective, this really important value of consistency with democracy. And other scholars have made other why arguments, right? The natural rights argument, the consequentialist argument. So I think the question is right. These are 2 different things, but they are related because you need an answer to why, unless you're going to argue. I think the only way out of that, McGuire, is to argue that, and some scholars have made this argument, is to argue that our constitutional practice right now, when you look at it just right, is actually an originalist practice. And I agree that there are some aspects to the practice that's an originalist practice. So for example, I'm not aware of the Supreme Court majority ever saying that originalism doesn't matter. They always seem to say it matters whenever they talk about it, although sometimes they don't talk about it, of course. And so there are some aspects where it's consistent, but I think there are a lot of aspects of the practice that are inconsistent with originalism. And so what you need is, if you're a judge or justice and you have before you a non-originalist precedent that's inconsistent with the original meaning, you need an answer to why you should follow the original meaning and change the practice. And democracy is one potential answer.
So we have a couple more questions in the queue that I think we'll address, and then one more wrap-up question.
Sure.
So another policy proposal that one of the questioners asks is, what about increasing the size of the lower courts? We talked about what has been pejoratively called court packing the Supreme Court, but what about lower courts? What impact does that have on originalism? What does originalism have to say about that? And how would it preserve its viability?
Yeah, I would say the answer is similar but different than the answer I gave earlier about the Supreme Court. So here's the similarity. So the similarity would be that more lower court judges means that the president and his or her political coalition gets to appoint more federal court judges from each party that wins the presidency on kind of an ongoing, more regular basis. So there's value in that. The point that I made earlier about the Supreme Court justices being from a very thin slice of America and therefore not representative of different perspectives, that doesn't apply. It applies to some degree, but not to the same extent as the lower court judges, especially to the district court judges, because in many states, I'll give Ohio as one example, the state senators have a significant role still in who the district court federal judges are going to be. And those states, those US senators from those states tend to be pretty politically attuned to what's going on in those states. So I think we actually get a little bit more value from the additional perspectives point that we made earlier. And again, that's assuming that democracy means consistency with current majoritarian preferences.
Along those lines of getting different perspectives, one more audience member asks, instead of changing the amendment process of Article 5, wouldn't it help if the Supreme Court just decentralized more issues rather than centralize them? The questioner gives the example of abortion, in effect, overturning Roe against Wade and returning the issue back to the states. Is that theory of interpretation consistent with originalism? Is it consistent with democracy? And which one should come out ahead?
Sure. Uh, I think the answer is it depends. So abortion is a great example from the questioner's perspective. So the product of Dobbs was to say that the federal Supreme Court basically has not much to say about abortion. And so far, Congress has not had much to say about abortion. If it did, that would be, under most people's lights, a Democratic proposition. And so what you have is states in a state-by-state basis, some through their ordinary politics, some through their constitutional politics, addressing the issue of abortion. So that does seem to be a win. To the extent you think democracy is valuable, that seems to be a win for democracy. But on the other hand, there's lots of aspects, I tried to emphasize this before, where originalism, there's not a democracy enhancing way to interpret some parts of the Constitution's original meaning. And that can be in terms of, think of the free speech clause limiting what states do, or the establishment clause limiting what states do. It can be in terms of, think of enforcing the proposition of limited and enumerated powers, what that would do to the federal Congress. So I agree, there are some aspects of originalism where properly interpreted actually decentralizes things and moves things back to the states. But there are other aspects where I think we just have to bite the bullet and say originalism has some anti-democratic aspects from the perspective of current majority preferences.
All right, so I've noticed throughout this discussion, it seems like you've been really careful not to say that originalism is a perfect, flawless view of constitutional interpretation, but rather that it's the best theory of interpretation, or it's preferred to all the others. It reminds me of I think the Winston Churchill quote that democracy. Well, and democracy, it's talking about democracy, which we're talking about being the best system except for all the others. Yep. So, other interpretive theories of the Constitution, other coherent theories of constitutional interpretation, do they suffer from similar faults? Are they also anti-democratic in some ways? And compared to originalism, is it a fair critique that originalism is uniquely anti-democratic?
Yeah, that's a good question. And one reason why I like that question, McGuire, is that in the debates over constitutional interpretation, it's all relative, right? It's not that, if originalism isn't perfect, therefore it loses, or if living constitutionalism isn't perfect, therefore it loses. It's which one, by whatever the metric we think is the relevant metric or metrics, is the better or best theory of interpretation. And one metric that many people care about is democracy. So we've been talking about that tonight. But living constitutionalism has its own so-called democracy deficit, right? So I think what characterizes living constitutionalism is that something other than the original meaning, which is going to be identified by Supreme Court justices, and they're going to have different views of where this other thing comes from, is going to be a source or input for what the meaning is today. And so when you think, going back to our earlier conversation about Supreme Court justices, the organ of articulating living constitutionalism isn't particularly democratic, right? It's the Supreme Court justices. I said they come from a narrow slice of America. That's all true. And so so living constitutionalism can't have an advantage because of who's articulating the living constitution, because it's the Supreme Court justices and they're not especially democratic. So what about some of the sources or propositions of living constitutionalism? So some scholars have made this move. I'm thinking here of Bruce Ackerman and Jack Balkin. They've made the move that living constitutionalism looks at popular constitutional movements. The Supreme Court is often, although not always, a mechanism of identifying and then constitutionalizing those popular constitutional movements. So, for example, Bruce Ackerman would argue, I think this is probably one of his most persuasive parts of his series, We the People, that the New Deal coalition was broad and deep and chronologically long, and that the New Deal had a different interpretation of the Constitution, that the Supreme Court, in its New Deal precedents that you've probably read, cases like Wickard versus Filburn, embodied those interpretations, not in the text of the Constitution, but in non-textual amendments embodied in the U.S. reports. So there's a sense in which the living constitutionalists are trying to grapple with the concern that we articulated, which is that the Supreme Court is not obviously a democratic organ. And the way they do it is by saying the Supreme Court is tapping into these popular constitutional movements. And again, there's some truth to that. I don't know if that's that powerful. One of the things that's always struck me is that outside of some areas of consensus, like maybe the New Deal Supreme Court seemed to be doing a fair amount of democratic adaptation. A lot of the things that living constitutionalists point to don't strike me as being that popular. So you and I were talking earlier about the right to keep and bear arms. The polling that I see typically shows that 60, 70% of Americans support some version of a relatively robust individual rights protection. But I don't see the folks in the kind of living constitutionalist camp arguing for a popular constitutional movement to have a very robust interpretation of the Second Amendment. And then on the flip side, when you look at other of the popular movements that living constitutionalists have point to, they also tend to, this is my perspective, they tend not to be kind of mass movements. They tend to be movements of elites. And so you have elite signaling in the law professoriate, in the state and federal judiciaries, maybe a few legislatures here and there. They're doing all the work in the popular constitutional movement, whereas the American people are not. An example might be, think of the death penalty. So the abolition of the death penalty movement really reached its high point in the 1970s, and the Supreme Court came within a hair's breadth of purportedly outlawing the death penalty under a non-originalist interpretation of the Eighth Amendment. The court backed away, but when the court was looking at heads, so to speak, counting heads, so to speak, it wasn't average American heads, because the polling data suggested that the vast majority of Americans continued to think the death penalty was legitimate in many instances. And so my critique of the living constitutionalism being consistent with democracy is that it tends to not have, as a practical matter, actual democracy, but it tends not majority preferences, but what I would say elite preferences.
Wonderful. So as we're wrapping up, are there any other thoughts that you don't want to leave on the table that you think are important to be addressed here with respect to this topic?
Yeah. I guess I would say, like, just the general theme or the general narrative, which was democracy was actually what almost all scholars were arguing about in the 1970s and early 1980s. And then it kind of died off, but it's kind of come back up again, I would say, over the last 10 or 15 years. So it's an important aspect for us to be engaging in. And there's a way in which, especially the more recent scholarship by Professor Whittington and Professor Elisea, have kind of revived the originalist perspective on that. And they're great articles. But I would say still the majority of originalist scholars think that democracy is a good, but not the ultimate good. And so other things are what justify originalism.
Wonderful. Well, Professor, actually, there's one more question that showed up in the queue. So,
okay.
Dealer's choice. Do you want to take it?
Sure. Is the one about Justice Scalia? Is that the one?
Okay. Yes. Yeah, I can read it still, but I just wanted to make sure.
I didn't know if there was another one, so go ahead.
For sure. Yeah. So the question is a long-winded one, but it's Justice Scalia had major issues with the 17th Amendment. So if I recall correctly, the 17th Amendment deals with the direct election of United States senators. Sure. The changes to the power dynamics of the government system design. Senators no longer beholden to the House. It goes on in the overall design. There are forms of participatory democracy, pluralist democracy, and elite democracy. How do you feel about the 17th Amendment changes with respect to the ability to allow for originalism? If you indeed agree that the system is changed post-17th Amendment in such a way that the power dynamics no longer allow for the proper examination under the views of originalism. Yeah, we'll let you take that one, Professor.
It's a great question. And it's interesting because when I teach constitutional law, which I do every year, sometimes multiple times a year, I always describe the Income Tax Amendment and the 17th Amendment as being two of the amendments that over the long term structurally change the Constitution, or at least how we operate the Constitution in a deep way. And so this is taking on board, I think, that perspective. So if we think about what is originalism, originalism is a theory about how to interpret the Constitution. And you and I tonight, McGuire, have been talking about one justification for why we should use originalism, which is democracy. There's other ones out there as well. And the question here is asking something a little bit orthogonal to originalism. So originalism would be, how do we interpret the 17th Amendment? And the question is more about what are some of the implications, maybe negative implications, of the 17th Amendment. And so it's not, I'll take my originalist hat off just briefly and say, the 17th Amendment, I've got two thoughts on it. So one is that as a matter of practice, I think it had a change, but not that significant, because many states, by the time the 17th Amendment was adopted, had actually on their own state laws changed how senators were selected and moved most of them to being in some form or another directly elected by the populace. So the 17th Amendment was more actually ratifying a change that had been occurring already in the states. Second, and kind of a little bit on the flip side, it's that when you think about what the Senate's role was originally, maybe this is what the questioner is getting at, what the Senate's role was originally was to protect, among other things, the structural principle of federalism. And to the extent that senators were beholden to the states, in other words, as legislatures, which are an institutional organ of the state, then they were more likely politically to to want to protect that structural principle of federalism. And to the extent that senators today they're still elected from states, of course, and elected by, and I think they genuinely perceive themselves as being representatives of those states, but it's different, right? It's not the state legislature as an organ of the state. It's the political party that's dominant in the state that elected me. So my point is that they're not necessarily representative of the state as a state. They're representative of the people of a party of a state that have supported them. And those interests may often align, but they don't align as often as previously. So I think one of the consequences as a practical matter is that the Senate has become less a forum for protecting federalism.
Well said. Wonderful, Professor. Thank you so much for your cogent participation and for putting on this series. I think it's been really helpful to flesh out some of the most important debates in the space of constitutional theory and constitutional interpretation. And to the audience, thank you all so much for coming to part 7 of the series on challenges to originalism. We will be here again next week for part 8 with our friends at the University of Michigan Law School student chapter. For today's event dealt more with a critique that often comes from the left about originalism, that it's anti-democratic. And next week's we'll deal for one that comes from the right, which is whether or not common good constitutionalism is superior to originalism. We hope you're able to join us, and it should be a good time. We'll look forward to seeing you then. Thank you all for coming, and I hope you have a great rest of your evening.
Thanks, McGuire.